Good morning, everybody. Until the previous video, we have completed discussions up to Article 213, which is related to the power of the Governor of a state to issue ordinance during the recess of the state legislatures. Today, let us discuss about the provisions contained in the Constitution with regard to high courts of each state of the country. There is not anything new to discuss in this chapter from Article 214 to 237, other than what we learned regarding the Supreme Court, which was contained in Articles 124 to 145. I will be reading the provisions of the Constitution verbatim of each article only with a view to let you know the relevance and importance of the Governor of that state and the President of India with regard to administration of justice in India through high courts. And regarding independence of judiciary also, we have already made elaborate discussions. However, I will make a very short reference to those discussions again. My purpose of starting this, now let us start dilating on each article relating to high courts of states. Article 214 says that there shall be a high court for each state. 215 says that every high court shall be a court of record and shall have power to punish for its own contempt. Court of record means the judgment of a high court shall be useful as a precedent, as a guidance for all the lower courts under it. Article 217 says that every judge of a high court shall be appointed by the President of India under warrant. Supreme Court and High Court judges are appointed by the President of India under warrant, who have certain prescribed qualifications. However, finally, whoever is in the opinion of the President of India is a suitable person to be appointed as a judge. Article 218 says that Article 124 clause 4 and 5 also apply to High Court judges. I have already told you Article 124.4 was relating to impeachment of judges. The same principles apply even for High Court judges, Auditor General, Election Commission of India. Article 124.5 relates to misbehavior and incompetency of judges. We have discussed the High Court and Supreme Court judges are impeached for misbehavior and incompetency. What is misbehavior and what is incompetency shall be decided by the Parliament. So you may understand appointment of the High Court judges and their impeachments is in the hands of the Parliament and the President. Of course, appointment is in the hands of the President, but he does not have power to remove them. To impeach a judge, it requires an address in any one house of the Parliament, and it has to be passed by both houses of the Parliament with a 2/3 majority, and finally with the signature of the President, a judge is impeached. This is the kind of unique independence given to independent Indian judiciary by the Constitution through Dr. B.R. Ambedkar. They are appointed by none other than the President of India, and he has no power to remove them. To remove them, he needs a resolution of both houses of the Parliament. This is the highest form of independence enjoyed by any authority in India. As such, judiciary and the constitutional authorities are given the highest form of independence. Without understanding this, the Honorable Supreme Court passed orders in Supreme Court Advocates on Record versus Union of India that the judiciary, to safeguard the independence of the judiciary shall not be answerable to the Parliament and the President. Thereby, instead of independence, the judiciary gains dominance over the Parliament and the President, which is not good for the country in due course of time. Transfer of judges is in the hands of the President. Appointment of additional judges or appointment of a Chief Justice in case of a vacancy. Their service conditions, benefits, leave, salaries. Of course, salaries are decided by the Parliament. Until the Parliament decides, they will be paid remuneration as per Schedule 2 of the Constitution. However, now the stage is that The salaries of the judges are decided by the parliament, by law. That you can understand, it is the parliament and the president together are involved in determining the remuneration and working conditions of the judges. We know president and governors are given powers under Article 72 and 161 to waive or reduce punishments issued given by the courts, including death penalty, whereas courts are not supposed to summon the executive to the courts. Courts are also not supposed to interfere with legislative proceedings under Article 122 and 212, even if such proceedings are irregular. That means the Constitution made a clear distinction line between the judiciary, the executive, and the legislatures. The functioning of the judiciary is kept under surveillance of the legislative and the executive, but legislative and executive functions are beyond the judicial interference. Thus, jurisdiction, its extension or reduction is also in the hands of the parliament. Under Article 226, high courts are authorized to issue certain writs such as habeas corpus, mandamus, prohibition, certiorari, quo warranto, etc. writs to safeguard the fundamental rights of the citizens and straighten the actions of the government and governmental agencies when fundamental rights of individuals are affected. Under Article 227, each High Court shall have a controlling power over the subordinate courts in the state. Article 228 says that the High Court shall be empowered to take up any case which is pending in lower judiciary if any substantial question of law or constitutional law is involved in such case. After deciding that issue, the case may be sent back again to the lower judiciary, or the High Court itself may decide the whole of the case. The Parliament by law may expand the jurisdiction of a High Court. Let us now discuss about appointment of district judges. District judges are appointed by the governor of that state. Their service conditions, etc., are also decided by the governor of that state, whereas judiciary below the district court are decided by the respective high courts. So overall, you might have understood by this time that the constitution of the courts, their jurisdictions, salaries, remuneration, and working condition of the judges, their behavior and competency are the subject matters of the executive and the legislatures. Unfortunately, Indian polity present judiciary has failed to understand the role of executive in administering this country. Honorable Supreme Court held in State of Tamil Nadu versus Union of India that a president is bound to assent or return a bill which is passed in the Legislative Assembly. This is a death blow to democracy. Of course, there is no democracy in India so far. Democracy has not taken its roots in India in accordance with the Constitution. In a democracy, there should be legislative and executive separately, and there should be separation of powers. If you say that executive is bound by the advice of the Council of Ministers, there is no effective executive. Without executive, there is no question of separation of powers and there is no question of democracy. Why this has happened? Because Indians have failed to understand the two sections of the legislatures in India should be the president, the union ministers, and their parliament members in the parliament. The governors, the state ministers, and the party legislators of that political party which is related to the President of India or his coalition parties. These are called, this is an official section. Party in power, treasury benches, or ruling party or ruling coalition. All others are opposition parties. Sometimes opposition parties may be in majority in the legislatures, like in the United States of America. If the president and governor do not command majority in the legislatures, that is the most ideal democracy. If a legislative leader is also allowed to rule, his word becomes law. Whatever he says will become law, and he is also the implementer. He becomes a monarch, dictator. He oppresses the opposition party resorts to rampant corruption, challenges the union government, and it leads to political party rule, family rule, caste rule, and purchasing of votes with notes to gain legislative majority. This is not democracy. This is the end of democracy. Unless we understand the constitution and the basic tenets of democracy, India is bound to disintegrate and lose independence in due course of time. In the meanwhile, there will be a lot of political instability, immorality, insecurity, social strife, poverty, external extremism, terrorism, and abnormal divide between haves and the have-nots. Let us hope one day epiphany devolves on the Indian administration to understand what is true democracy and what is contained in the constitution. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. I wish that this constitutional message shall permeate fastest and the widest, so that social, political, economic changes will take place in India for the good of the country. Thank you.